We have one more panel to go that's going to be on online platforms. And I'll introduce the moderator for this panel. And it is Mark Greenberg, immediately to my left, who's a professor of law at Golden Gate University. In looking at his bio, I'm going to cherry pick a particular line that I thought was the most interesting here. Professor Greenberg's scholarship has focused on legal issues pertaining to comic art, content on the internet, obscenity law in online contexts, and copyright issues in both US and China. So he's the perfect moderator for this panel. And with that, I'm going to turn it over. Please take over.
Thank you. Well, good afternoon, everyone, and welcome to the largest and last panel of the day. It's my pleasure to introduce the members of this panel. We've got a tremendous group because we're covering both national and international issues regarding a very interesting element of trademark law, and that is trademarks in the online universe and the sometimes uneasy relationship between trademark owners and the online platforms where trademarks play an important role. So we've brought together a group of people representing all ends of that spectrum, and we have the great opportunity to have as our lead-off panelist Mark Cooperman, who is a longtime partner with the Banner Witkoff firm, who's going to give us the state of the law, and he's also going to tell us about the hypothetical that we have put together as a panel, which will guide our discussion throughout the rest of the panel. We are followed by a colleague who's traveled a bit for us, Jinghao Wang from the Alibaba Group, will provide some insight into Alibaba as a platform and their relationship with trademarks and brands. And then shifting to a company that represents and deals with a great number of brands, Live Nation, which of course is near and dear to my heart because they're a successor to the Bill Graham Group in the entertainment arena, which is a little bit more in my wheelhouse. Eric Gelwicks is here to represent Live Nation. A very active participant in intellectual property law areas, and I'm pleased to say an alumni of Golden Gate University School of Law. Following Eric is Dan Chen. Dan Chen is a partner at the Unitawan Attorneys at Law firm in Beijing in the People's Republic of China. And she will bring that unique perspective to our panel. And then following Dan is Patchen Haggerty from Perkins Coie. And I got to tell you, if you're looking at the slides for this panel, which I encourage you all to do after the program as well, Patchen has put together one of the best reference listings I've seen on trademark and online platforms. So for those of you who are practitioners as well as students, this is going to be a great resource for you after this conference, which you'll continue to use, I expect, for quite a long time. I can heartily encourage you to take a look at her slides. And then we're going to hear from an American-based platform, one that we're all familiar with because after the Christmas holidays, we all did a lot of shopping on Amazon, and Michael Kelly from Amazon will give us that platform's perspective on this very interesting question of the intersection of trademarks and platforms. And then finally, and of course it seems fittingly, to give us a role, sort of as playing the role of discussant and giving some feedback on the overall panel, as well as offering some commentary on the interesting problems of what happens when you see things that are, let's say, endorsements of a particular brand that you think are coming from a consumer or a fan of the brand, and in fact it may have been a plant by the company. How do platforms and brand owners deal with those issues? Our own David Franklin, who will bring us home at the end of this panel. So the best part for me as the moderator's job is I'm done. And it's my pleasure now to turn over the podium to Mark Cooperman.
Good afternoon, everyone. So what is going on in the world of online platform law from a trademark perspective? Short answer, right up front. It's kind of still the Wild West. And that's because there's not a lot of law out there. And when you manage to find that law, it's pretty darn muddy, as we'll see. Mark mentioned that we created a hypothetical for our panel to kick around. So like any good Western, our hypothetical has several starring roles. Our good guy protagonist is our brand owner. You can think of them as a rancher out west. They sell authentic Pucci, that's with a P, handbags. Our bad guy, our antagonist, is our infringer, our company that's selling counterfeit products or products that look a lot like the authentic Pucci products but maybe aren't counterfeit. You can think of them as the cattle rustler. So that's the setup. Now, where is this all going on? It's all on, we've been talking about online platforms. We mean like a marketplace, like Alibaba or Amazon. And there's sales of authentic products and counterfeit products and infringing products on there. What role does the online platform play, and how are they potentially liable? Are they a supporting role, or are they a starring role? Well, under the law, sometimes they're looked at as an innocent bystander. Sometimes they're looked at as a business owner who's trying to expand in the marketplace, maybe at the expense of the brand owner. Sometimes they're expected to be part of law enforcement, as we'll see. So the good news is, way out west, still first principles of trademark law apply. We have essentially two types of buckets of potential liability for our owners. We have direct liability, which basically bases on any actions that you take, regardless of your state of mind. And then we have potential indirect infringement. That requires some knowledge, some forethought. And that's pretty standard in normal trademark analysis. So the case to know in this area is the Tiffany versus eBay case. If you're going to read one case, you should read that one. Now, it's already almost 9 years old, but this is a case to read. And in Tiffany, there were sales of both authentic Tiffany products and counterfeit Tiffany products on eBay. eBay had a big problem with counterfeiting. There was a ton of it going on, not only for Tiffany products, but for other products as well. And eBay knew that they had a problem. The Second Circuit concluded that there was lots of knowledge, lots of evidence that eBay knew what was going on. And eBay didn't ignore this. eBay took precautions to try and solve the problem. They created a trust and safety team, they called it. This is a group of hundreds of folks who processed brand owner complaints that were sent to eBay about infringing products being sold on eBay. They had a notice and takedown provision set up. And remember, we're not in copyright land. We don't have a statutory safe harbor for notice and takedown like we do under the DMCA. We're in trademark land, right? And in trademark land, right now at least, each independent online marketplace needs to kind of figure out their own way. And I'm sure we'll hear from Xing Hao and Michael about how they handle these notice and takedown procedures. Despite all this effort by eBay, Tiffany still sued them, alleging direct infringement, indirect infringement, dilution, et cetera, et cetera. Conclusion at the end of the day, no culpability, Second Circuit says. So let's dig a little bit more into the direct infringement bucket. Typically in this situation, we're focusing on sales of trademark products. Now, if the sales are by the platform, like Amazon, for example, sells products directly, they're the actual party that are selling, then the traditional trademark analysis, looking at likelihood of confusion as to source, would apply. It gets more complicated, though, in the Amazon and Alibaba world, where we're dealing with an online platform where there's third-party sales of the trademarked products. And that was the case in Tiffany. These were almost all sales of actually used or resold Tiffany products on eBay by third-party sellers, not being sold directly by Tiffany, by eBay. So at the end of the day, the court in Tiffany concluded that there was no liability for direct infringement, basically on a fair use type of analysis. But there's an interesting question. This is some of the mud I was talking about. Did the Second Circuit suggest that the platform's knowledge and response to all these complaints mattered in the direct infringement analysis? So this is the Second Circuit. eBay's knowledge is relevant, and I'm reading the bolded portion. eBay's knowledge is relevant to the issue of whether eBay contributed to the direct infringement. So that's talking about indirect infringement, right? But I want to focus on direct infringement. But it is not a basis for a claim of direct trademark infringement against eBay, because eBay promptly removed all these listings. I missed the most important part, especially in as much as eBay promptly removed all the listings. So that language, especially in as much as, was the Second Circuit suggesting that if eBay hadn't promptly been a good guy and removed all these listings, that they might have been able to be found liable for direct infringement? That's one potential takeaway in some of the mud that we all can be arguing at down the road. So in addition to sales of products leading to potential trademark infringement, there's potential liability for false advertising, and that was one of the claims in Tiffany as well. If the ads use the trademark at issue and cause deception or confusion. The Second Circuit actually gave Tiffany some traction on that and sent the case back on remand. At the end of the day, the district court found, again, against Tiffany, but that is another avenue or another path for all of us to keep in mind when and if we are dealing with our friends at the online marketplaces. And as a reminder, another path for potential direct infringement online are meta tags. If you're using the trademark embedded in meta tags or search algorithms, that could be another source for direct trademark infringement liability for brand owners against potential infringers online or marketplaces. Let's turn to indirect infringement. Here, the focus is really on the knowledge of the marketplace and what actions they took or inactions they didn't take in response to that. The leading case here to keep in mind is the Inwood Labs case. Now, this is a Supreme Court case from over 30 years ago. Not surprisingly, it didn't deal with online marketplaces, but it did deal with the standards for indirect infringement and the state of mind that's required in order to prove indirect infringement. And post Inwood Labs, the cases that have applied it in the marketplace context have focused on this second prong down there that I have bolded. And generally what the courts look for is, did the marketplace continue to supply a product or service? And the service here would be providing a marketplace online for sales. So did the marketplace continue to supply their services to one it knows or has reason to know is engaging in infringement? That's the standard, requiring some level of knowledge. Inwood Labs. Back to the eBay case, they took the Inwood Labs case, applied it, and concluded there's no indirect infringement, because that's what we're talking about now, because though there was lots of evidence of general knowledge of counterfeiting going on, it wasn't product specific. The language that the Second Circuit talked about was knowledge of which particular listings is what you need to have as opposed to general knowledge, general takeaway. I'll ask you, what does that mean? Which particular listings? Knowledge of which particular listings? That can mean, I think, a lot of things depending on what details you pass on to the marketplace or what details you know. Another way to fulfill the Inwood Labs standard for knowledge, some courts, is if the marketplace, if you can show, has direct control and monitoring of what's going on the marketplace. It's a substitute for that specific knowledge. And then finally, willful blindness. This has been accepted by a number of courts. Again, even the eBay court commented on this. And this could be another substitute for the Inwood standard of knowledge in order to prove indirect infringement. We've got a couple cases up here that talk about that. The Louis Vuitton case, intent may be imputed as a result of service providers' knowing failure to prevent infringing actions. So what this seems to be saying is if you know that there's some infringement going on in your marketplace, some counterfeiting, you have an obligation to act. At least that's the potential implication. Not clear, it's kind of muddy, but that's the implication from the willful blindness language. And pretty much that's all I've got.
Great. Perfect.
Thank you.
Thank you, Mark. Now we'll hear from Xinghao. So, right side to advance. Should be coming up.
Okay. So before I start, I just want to make two clarifications. First of all, I didn't travel long distance at all.
I did.
I travel from Queens, even though
Oh,
it's
that's a
not
long
very it's not very pleasant to travel in New York traffic. That's for sure. Second, I would not describe our relationship with the rights holder as uneasy. In fact, I think collaboration is the best tool, I think, to fight against online infringement. And my role actually is that I station in New York, and my role, as well as we have a team of the 6 people, is to collaborate with stakeholders, including rights holder associations, government, and try to address the infringement issues. And we also have a similar team, actually a larger team based in China that work with rights holder in China as well. And most of rights holder, international rights holder have their branches in China, so they work with them directly. So, but anyway, so what I'm going to do today is basically just only have a few minutes to talk about our framework of IP infringement. And I will mainly just focus on the notice takedown part, because that seems to be the focus of today. But before I start that, I just want to give you a little bit flavor of what Alibaba is, right? So Alibaba is not really, we don't consider ourselves as an e-commerce per se. So what we are trying to do is build an ecosystem or technology to enable anyone to do e-commerce with anybody around the world. So that's actually is our vision. And as you can see, we already built a very complicated ecosystem, which include retail commerce. We have various different platforms for different business models. And we have entertainment platforms, including like Youku and a few other platforms that provide contents. And we have a local service which basically connect your local vendors, including restaurants, coffee shops, to you so that they can deliver a service to you. And to enable all those e-commerce activities, we also build a logistics platform which basically connect logistics service provider with the person who needs the logistic services. And we also have a payment service called Enter Financial, which not only facilitate transactions, but also facilitate like a microloan type of financial products. And beyond all those, of course, is built on our Ali Cloud platform, which is a separate service for clients. So as you can see, what we are trying to do is basically to build an ecosystem for your digital life, every aspect of your digital life. And so what we're trying to do is to want you to spend more time on our platforms. So to do IP enforcement on this complicated ecosystem, basically we have a 3-pillar approach, right? One is a notice takedown, where as we just talked about, is a reactive to the notice submitted by rights holder. Second, we do have a very robust proactive monitoring where we use technologies and algorithms to try to identify problematic listings. Those algorithms not necessarily just rely on the product knowledge itself, but also rely on seller behavior, user comments, not a single criteria, but a combination of those criteria to decide which seller or which listing is problematic, and then we remove that. The third pillar actually is offline investigation, offline enforcement, I would say, because it includes basically offline criminal investigation and offline civil investigation. In the criminal investigation, we basically collaborate with Chinese police on their investigation against counterfeit products, and we also work with rights holder to facilitate their investigations on offline targets. But we also initiated our own civil litigations against the seller on our platforms for their breach of a contract because they sell counterfeit, so it's a breach of our contract with the seller, and we use that as a basis to file civil litigations against them. And all those pillars, essentially the idea of those pillars is to increase the cost of infringement on our platform. So that's a deter infringement. But today I'm only going to focus on the notice takedown part of the first pillar. And as you can see, as a platform operator, our notice takedown process is also a platform-based. So we have this one-stop platform that for rights holder to register their account, to submit their IP certificates, and then to submit their takedown requests so they can track the process of the notice takedown. Then that's how we do it. It's a specialized platform for rights holder. And we have essentially have 6 main e-commerce platforms, and you can submit takedown requests against any of those any of those platforms in this platform. But there's something I want to actually point out here. Now we have 6 different platforms, and some platforms like Taobao, Tmall Global, and 1688 actually are Chinese-based platforms. And 2 of those, Alibaba.com and AliExpress, are basically international platforms. So we do have different rules, right? For the Chinese-based platforms, we do require you to have a valid IP in China, right? You need to have a trademark register in China, a patent rights register in China, and copyright. You don't have to register in China, but we do require a statement saying you own a copyright. But the copyright applied to any of those platforms. But for the international platforms, then you can actually enforce your IP rights, for example, valid in the US. So we do have different rules. And our approach essentially is if you submit a takedown request, and when we remove a listing, right? When I say when we remove a listing, so the process looks like that, right? When you submit a notice takedown, there is a review process to see, okay, whether it is this is a valid takedown request. If it is, the listing is removed. Then the seller gets a chance to respond to that notice, and they can submit evidence saying rights holder made a mistake. So you know, if the counter notice is accepted, then listing will reinstate it. But counter notice is rejected, then listing will be permanently removed. And at that point, seller will actually get a penalty. The penalty is not a fine, not a money penalty, but it's associated with your online activities, right? Maybe your search ranking will be reduced. You will be prohibited to do advertisement. You will be prohibited to use social tools on our platform, and all your listings may be temporarily removed, your stores, until the shop will be permanently closed. So there's escalating penalties against different IP infringements. So that's how we deter the IP infringement. It's not just a removal, but at the same time we also impose some of the limitations on their online activity. And those limitations are actually pretty severe because the online traffic is the lifeline of any e-commerce shop, as you know. And any of these limitations will substantially reduce their traffic. So as an online platform, obviously the advantage is that we can put a lot of data into your fingertip. So we have dashboards to show your statistics and your status of takedown request, things like that. And we do publish, we're very transparent about our IP effort. So we do, annually we publish IPR annual report. And at the same time, we also have a handbook so that to help rights holder to help their online activities. And in fact, just a month ago, we just published a Chinese version for the 2018, but we have not translated that into English. So we will see the update very soon. So, but the one thing I have 1 minute. So after, as I said, we have 3 pillars, right? Notice takedown, proactive monitoring, and offline action. So people may ask, what's the result, right? So for a long time, we're not so sure whether our system actually works. But this time, we're very sure. The reason is that, first of all, we see substantial reduction of notice takedown, number of notice takedown submitted by rights holder. Second, we actually see substantial reduction of the listings we proactively removed. The third is that we have a channel for consumer to report suspicious listings, and that is also substantially reduced. And the fourth is consumer refund request based on counterfeit is substantially reduced. And also, we help authority on their investigation, and the total number of investigation requests coming from authority also substantially reduced. So all those parameters basically indicate that after so many years of doing this 3-pillar approach, it's actually really start to work, and we feel confident about that. And as I said, collaboration is the key. So I guess my suggestion is that work with us, use all those tools available to you. And I think I stop here.
Great.
Thank you.
All right, so heard it from one side, heard the foundational law, and now you're going to hear it from the brand owner side, but I don't think it's going to be that controversial. So on that note, quick disclaimer, I'm speaking on behalf of myself and not the comments, opinions of Live Nation or the artists that we represent. So I work in the merchandise division, which supports tour, retail, e-commerce, licensing for all the artists that we work with and their marks. So we've thrown out the sort of general word platforms, and I just wanted to clarify the type of platforms that I specifically work with on pretty much a daily basis to sort of fight the counterfeiting issue. So the marketplaces, we've heard from Amazon, Alibaba, et cetera. There's what I sort of call e-commerce solutions, and these are either website builders or e-commerce toolkit that somebody can build a standalone website and sell products. So they have their own unique URL. They have their own owner that can be anywhere in the world. And as representative from Facebook talked about, sometimes it's really difficult to track those people down, especially now that the WHOIS information is hidden from public eye. We deal a lot with print-on-demand platforms. So, it's sort of like a marketplace, but the products don't exist until someone orders them. This allows somebody essentially to download content from anywhere on the internet, including pre-vectorized images, throw it up on a template t-shirt, and all of a sudden they're selling a product. There's no cost to entry, and really if something gets taken down, there's no ramifications because they haven't had to invest in any inventory. And then the social networks. I think there's almost always a marketing campaign that goes with sort of sophisticated counterfeiting operations. So if you're not taking it down on those platforms as well, you're usually going to get caught with, get something down and then immediately pops back up through the same social media channels just with a new link. So that's sort of the, so-called battleground that we work on. As Mr. Kumaran highlighted, the law kind of favors a whack-a-mole game. And I actually described it earlier, somebody as sort of whack-a-mole combined with Risk, if you're familiar with that game, except the other players in the game are invisible and they just get a pop-up wherever they want to. And then you can get rid of them, you can win that battle, but then you have to move on to somewhere else. So you're really just reacting in many cases, and that's where I think platform and brand owner partnership is really important to sort of preempt the bad actors, try to get a screening program up, which I'll talk a little bit more later. And I think it's important to emphasize that some platforms, especially the e-commerce tools, make it extremely easy for a bad actor to create and then mirror websites and have the exact identical stores under multiple URLs. Creating, doing the investigation to create a link between those is very important. Some of the tools, because of GDPR, have been pulled back on. And, the last point I emphasize is that some platforms make it very difficult to take stuff down, but they make it very easy for a seller to sell something. So, for instance, we represent, a lot of artists and they're celebrities, and we have to upfront submit information saying that we're authorized to use it, get a signed statement with personally an address, a phone number for a celebrity that might be on the trademark listing, which we're just not going to do. So those are hurdles that end up in our way that we have to kind of overcome, work with either their management team or outside counsel to figure out, and then go after the various bad actors. So as I mentioned, I think the partnership is component, and as Alibaba mentioned and talked with Amazon before, is a way to streamline the process. And the best way to do that is to find somebody internally that you can work with, you can discuss the issues that you're seeing, and set up a system, whether that's technological or it's actually eyeballs on products. Obviously, the scale is sometimes difficult to do that, but we do have that in some circumstances. But really just have a two-way street of, here are the issues that we're confronting, here are the issues from my end, like we would like you to address. We're able to identify often, with some really high level of certainty, what products are legitimate and what products are suspected as being counterfeit. So educating the platform on what to look for, if there's no legitimate resellers in certain jurisdictions, that maybe those products get flagged for certain reasons early on and warrant additional review. So it's as I emphasize, you can talk about technology, you can talk about blocking systems, and really that's going to help you out in the notice and takedown context as well, because you're going to have a lot less products to review, and once you take something down, hopefully, ideally, it wouldn't show back up, but we all know that's probably not the case. It'll show up somewhere else. So, just having the ongoing two-way partnership and, collect information that you can share from your end, the platform's end, to really improve whatever technology they're using, or to build on what they're doing. So image recognition is one way that you can do that, or looking for keywords using OCR or something. So we heard a lot about different types of IP, European design, registrations, and things like that. And for different IP owners, the strongest IP is going to differ. So in some cases, it might be the trademark. That might be the broadest IP that you can apply internationally. As we heard from Alibaba, some circumstances, you'll need filings in China, or in other circumstances, we deal with platforms where you'll need specific filings in Indonesia or India. So, and you might be dealing with a client like we do that filed one application in Class 9 and forgot about their trademark portfolio for many years. And for us, going back and trying to plug the holes in Class 25 for clothing, 16 for paper products, 18 for bags, things like that, can be very important if we're really trying to enforce on a global scale. We also deal with publicity rights, and you can learn more about patent in another conference. I'm going to sort of gloss over this because I think a lot of people are familiar with the notice to takedown, other people are talking about it, but having a sort of toolkit of language, keywords you can send to certain platforms, and just templatized emails or letters that you can move quickly on stuff, depending on if you're in-house or working with clients. Some clients just care about getting the products down. Others really want there to be, an aggressive approach. So you might weigh whether or not it's just worth doing takedowns, taking some screenshots, coming back to it later, and how to build your case. And my time is just about up. So the last point I'll just emphasize is having a holistic approach to your brand owner and enforcement. So whether you're outside or inside, focusing on internal education. So you have various teams. We talked about working with marketing teams, but that can also be retail teams. They can be your eyes and ears on the ground. And then external, maybe creating products, or not products, but educational materials that you can provide to platforms or third parties that show, what is legit, what is counterfeit, and how to identify certain things. So that's it for me, but more to hear. Thank you.
Thank you for staying with us. Well, I know everybody wants to hear something new that they haven't heard before in other seminars, so I'm going to start with something new. We have an e-commerce law in China from January 1st, and it doesn't mean that we don't have an online platform system in the past. It's just that this is a reinforcement of all the previous efforts, and also it's no longer just like big giants like Alibaba who will provide such a obligation to implement such obligation. It will be all the e-commerce business platform runners who shall have this obligation to protect, to enforce your IP rights in China. And something else also related online is that from these years, this year, you will see more and more progress made by the trademark office and other administrative authorities online by giving more access to informations like certifications, like even changes of ownership, and even decisions made by the TRAP, which was not available online, but now the online platform is definitely helping you a lot. But what I'm going to talk about is something not new, which is the key part. The reason why I keep talking about something not new is because it's frequently forgotten. So when we are talking about online platform enforcement, are you really ready for that? I mean, there is platform and there is a system, I would say a really great system in China to enforce your rights. But you're sure you're ready? Let's take a brief look of what are the things you might want to do a first check before you take the actions. So do you really have enforceable rights in China? Well, someone may say, yeah, I have an international trademark which was filed yesterday and already got the certificate, and I can enforce that. That's not the situation in China, right? You have to wait for 18 months after the statutory examination period expires so that you can have a certainty that you have the rights to enforce in China. And do you have a valid proof of rights? Again, the international trademark owner says, hi, yes, I have this registration certificate or even a grant of protection issued by the trademark office. That's not enough. You will need to do something more. You have to file an application for certification of registration in order to enforce, not only to file online complaint, but also to sue at the court or to record that at the custom. And is your right broad enough? This is a particular question for U.S. trademark owners because so far as I know that your description of goods tend to be very specific. Well, that specific protection, would that be broad enough to protect, to back up all your enforcement actions in China? And what if the target, they have their own rights in China? What are the ways to deal with them? So we're getting back to the Pucci case, yeah. There's a scenario like this guy, he doesn't really sell in China, but he contracts a Chinese company to manufacture for exportation to US, back to US. But several months later, well, of course, he didn't do the registration in China because he thought, I'm not selling in China, so why should I register? I'm not using my mark. Well, actually, manufacturing in China is a kind of use of your trademark. So some months later, he finds this identical goods, actually manufactured by the same manufacturer, but sold online on the e-commerce platform. So you're thinking, Pucci is thinking about taking actions. But as I said, Pucci still does not have his registered trademark in China. How could he take the action? So here are the options. Go quickly get your registration in China. And you might say, oh, that's too long. Actually, it's not. The recent publication I have seen is an application filed in last August, and it's already published in January. So Chinese Trademark Office is taking steps to speed up the examination. So if you want a quick action, a quick rise, skip the international registration and go directly to Chinese filing. And, but he might turn out and finding that, oh, my application is rejected because the Pucci mark has been registered by my manufacturer. What shall I do? I won't be able to enforce. Well, not exactly. Maybe we can take a look at whether we might be able to enforce copyright even against a registered trademark in China, because we already have a successful court case about that. And as I mentioned, I won't repeat because of our time. And when you do the registration through Madrid, making sure you waited for 18 months, and you make sure the first thing after the 18 months to do is to get a certification of registration from the Chinese Trademark Office. And when you are trying to check, see what are the actual goods that are manufactured or sold by this manufacturer online, you may happen to find that the goods he sells is hosiery or socks. Well, your own registration covers only footwear. So this will actually be the very typical problems encountered by US applicants, making sure that you are not really mentally bound by the scope of goods you are currently using in US. We are thinking about protecting your trademark in China. Think more wider, think ahead. What are the things you might potentially want to protect? What are the things you won't feel comfortable if someone else register or use the same mark on it? So these are all the things that you really have to do a kind of self-check before you take the action. We see complaints about China is not protecting my IP. Well, sometimes you don't really not get yourself equipped enough to get this protection. So do this check, and then go ahead, you will be enforced in China. That's my conclusion. Thank you.
Gotcha. Right on time. Thank you.
All right, so far we've heard a lot about marketplace takedowns and some platform takedowns. I'm going to talk a bit about the rest of the universe. What happens when you have scammers and fraudsters who don't have any actual physical product? They're not counterfeiting anything. They're really just out to get your users and steal their money or their information. How do we go after those people? So the internet's continued to grow, and the most recent estimate is there are about 6 billion indexed web pages on the internet, which doesn't include social media. Active users of Facebook are in the billions, and active users of Twitter, Instagram, LinkedIn, and other social media are in the hundreds of millions. So this creates, obviously, a brand opportunity, an opportunity for brands to market and promote their brands, but it also creates a mecca for trademark abuse. So what types of online brand misuse do we commonly see? We see sale or counterfeit goods, has been discussed, but we also see a lot of impersonation and phishing scams, spoof sites, 800 customer service scams. And for those of you who aren't familiar with impersonation and phishing scams and spoof sites, these are scammers that register domain names that are close to identical to the brand name. Oftentimes they use internationalized domain names, so they look almost identical to the primary brand, except maybe there's a little tilde or an accent or something over one of the letters that's almost imperceptible in the URL. And then they will tweet out a link to a promotion from a Twitter handle that's close to identical to the primary brand. Users click on the link, they're taken to a login site that looks identical to what they're used to seeing from the brand. They enter in their user ID and password, and immediately the scammer has access to their account. If it's a financial account, oftentimes the money is drained, transferred away, and it's untraceable. If it's other types of accounts, users can get access to your personal information, your name, your address, your credit card information. So this is the type of scam that we are seeing, and we're doing a lot of enforcement programs against stopping these types of scams. In the 1-800 customer service scam, it's very similar. These scammers will post fake 800 customer service numbers. They'll either tweet them out or they will post fake support sites on social media sites like Facebook, or message boards where people are like, how do I actually get a person on the phone for such and such a company? Someone will respond with, oh, here's the 800 customer service number. You call it and somebody answers who sounds legitimately like you're calling into a call center. You give them your account information, and the same thing happens that happens with the phishing sites. Promotion of cheats and hacks for games. This is something that we do a lot of work with for our gaming clients. Hackers get a hold of the game code, they hack the code, and they figure out how to generate in-game currency or other virtual goods in the games, or other things like accelerated strength or the best player in the game, and then they sell the cheats and hacks through various means, and players buy these so that they can cheat and be the best at the game. This is a huge market that we're seeing a lot of activity in and doing a lot of enforcement in this space. Fake product or gift card giveaways kind of goes along. These are part of the promotions that we see that lure people in to click on these links. And then cyber squatting's been discussed a lot today. That's essentially just setting up a website that looks similar or is redirecting traffic to another site, either competitive or otherwise online. So strategies for protections of brands online. We've talked a lot about securing protection for your key brands, secure your relevant domain names and social media handles. This is tough now that there are so many GTLDs. So I usually just encourage brand owners to secure those that are most relevant to your space and some iterations of that, but you just can't get them all. And then maintaining that large portfolio of domain names can become quite expensive. And then engage in active monitoring for infringing activity. So in many rights, including the US, trademarks are use it or lose it rights. So if you're not out there monitoring and actively enforcing, if you're allowing customers to be duped or counterfeit products to be sold, it weakens your trademark rights such that eventually you'll lose them. So active monitoring for infringing is essential to retaining your strong rights and for protecting your consumers. So types of third-party trademark monitoring that we use on a regular basis are third-party trademark application watching services, domain name registration watching services, website content monitoring. This is really helpful, particularly if you have a larger brand, because it really helps narrow the universe of what you're being shown as use of your third-party trademarks online. Social media watching services, these are key. We have some watching services that will monitor social media 4 times a day and send out a report, and it's amazing. Each of the 4 reports has something that we need to take down. And then app monitoring services, also essential. So many apps out there that are using third-party brands. Self-monitoring, this is an overview. This really just depends on what your brand is, how big it is, how famous it is. But you, of course, can do Google or other search engine searches coupled with industry-relevant words like cheat, hack, free, giveaway, etc. You'll be amazed at what you'll find. And then set up Google alerts for brand mentions. Of course, this is at scale, depending on how large your brand is. You don't want to get inundated. And then set up alerts for refusals for third-party trademark applications through the USPTO, search the test database, and then register with the TMCH for alerts of newly registered domain names. So enforcement strategies, talked a lot about filing takedown requests with platform providers, website hosting services for illegal and fraudulent activity. This is where we focus a lot of our takedown efforts for the scammers and the fraudsters. The website hosts and sometimes the domain name registrars are particularly helpful in getting us getting illegal and fraudulent activity taken down. They don't want their services used for illegal and fraud. So they're really helpful. And then sending cease and desist letters. And then, UDRP complaints are effective tools for obtaining control of domain names that have been used with scams. We've found that if we don't file UDRPs, we just get the content removed and taken down, we see it come up again 6 months later. So it's essential to get control of the domain. And then, as has been discussed, working with a trademark enforcement specialist to develop an ongoing monitoring and enforcement program is key. It helps cut down on the whack-a-mole. It helps you be very strategic about what you're going after, where to invest your funds wisely. So getting to know takedown procedures, most platforms have them and will remove infringing content if it's blatant. Many require evidence of trademark rights, as we've discussed. Some platforms will investigate the claims. Others will put you in contact with the other party for direct negotiation. And before I show you the list I put together, I just wanted to give a quick example that just came up recently of this type of scam that was directed at the Deputy General Counsel for a client that we do a lot of online enforcement and takedown work. He got a call from an elderly woman who said, hey, someone just stole your identity and is using it in connection with this scam. And so he asked her to forward the emails and such. And it turns out, I'll call him John Doe to protect his identity. They had a whole scam put together, and they had these letters that were the law offices of John Doe Esquire that had his California bar number on them and the address for his former law firm. And it was an engagement letter for this woman to represent her in connection with going after a fraud, oddly. But there were numerous letters of these. There was an invoice. She had actually paid them $5,000 to engage them for this. And the email was sent out from a company called ClaimFed. And if you go to their website, they claim to be experts in going after all types of claims for personal injury, for timeshares, all kinds of things. So we took all of that, we investigated it, we investigated all the sites. We were able to report it to the site hosts, get all of the associated websites. We actually found 4 down within 48 hours. Send out cease and desist letters to the several addresses that we found associated with the scam, including what we think to be a real cell number, reporting it to the FBI, the FTC, and the FCC. And we also got a hold of the bank to which the funds were transferred and had them freeze the account so that we can work with law enforcement to try to get this woman her money back and others that were scammed. So this is the kind of brazen thing we're seeing out there. Personal names are trademarks, and we can enforce them in just the same way. So I just wanted to share that example since it's something that just came up. And here are my resources. I've gone through all of the app and marketplace takedown policies, social media networking, content provider platforms, and then the app stores. Whoops, they're mixed in there. So these will be in my materials. Each platform has a very different takedown policy, so I encourage you to read it in addition to filling out the form to cut down on the back and forth. And that will help with future enforcement campaigns. Thank you.
Okay.
Hello, I'm Mike Kelly from Amazon. There we go. I'm going to talk a little about Amazon, introduce brand registry, and then talk about how I use brand registry. We'll cover a couple of topics in the meantime. I will be sensitive to the fact that I think the bar opened 30 seconds ago. So let's dive right into it. Amazon's mission is to be the Earth's most customer-centric company. You might have heard that already. We talk about broad selection, low prices, convenience, but that's also about trust. So we have, in addition to Jeff's quote here, customer trust is key to Amazon's business. We're constantly working to earn and keep trust. If you think about Amazon when it first started shopping on the internet, giving your credit card out over the internet, that was very new. So we have another saying at Amazon that customer trust is hard to win but easy to lose. So anything that undermines customer trust is something that we take very seriously, and those things have no place on Amazon, and that includes counterfeit products. So we talked about third-party marketplaces, so I want to talk a little about Amazon's, frequently called Fulfillment by Amazon, or FBA. The way it works is that sellers ship their products to Amazon fulfillment centers. We store the products for them, even though the sellers continue to own the products. And then when a customer orders them, then we do all the logistics for them. We can pick, pack, and then ship those products to the end customer. We do that obviously for a fee. It's a logistical service. This arrangement enables third-party offers to become Prime eligible, which usually increases customer interest in products that are for sale on Amazon. And we also provide customer service support for the products that are being sold through FBA as well. So this is a really big kind of field leveler for small and medium enterprises who can go from product development to selling on Amazon in a much shorter time than if they had to develop these capabilities themselves. So this third-party marketplace has been very successful. So some statistics, we have over 1 million US-based small and medium enterprises selling on Amazon. Over half the items sold on Amazon are actually coming from the marketplace, so from small and medium enterprises. Those taking advantage of our logistical networks can avail themselves of customers in 180 different countries through 13 different marketplaces. So that's a huge footprint. The vast majority of these people are honest entrepreneurs. However, we do understand that there are bad people who want to do bad things on the internet. I think we all know that. So, this isn't just counterfeits for us. We're constantly trying to evolve to deal with other types of fraud and attacks and things that we might see online. And in fact, a lot of the times the people who are doing counterfeits are actually doing other bad things as well. So the main goal, and we'll talk about partnership, and that was brought up a couple of times on the panel, and that is key, but one of the things that we really focus on is preventing these bad actors from ever even reaching the customer. So we work hard, invest heavily on proactive prevention efforts. So as you can see, it's kind of a little bit of what are the kind of the scale and scope that we're working in. So the proactive detection requires us to scan a wide variety of inputs, why the seller might be bad or why the products might not be legitimate. It's a huge challenge to do. We have millions of sellers. We process billions of transactions a year. We make about 5 billion changes to our website on a daily basis. But that doesn't mean we're not focusing on this. We collect a lot of data. That data gets kind of run through our algorithms, and we are investing heavily in proactive prevention technology. That could be machine learning, data science. We have software engineers and investigators around the globe who are working on this problem 24 hours a day and 7 days a week. We like to look for risk signals throughout the seller and product experience. So that could be the IP address someone's signing up with. That might help us detect someone who's registering multiple accounts to do something wrong, or it could even be customer service contacts or customer reviews. All of these things can feed into as risk signals into our algorithms for us to proactively detect counterfeits and other problems. So our ultimate goal is to do this so that the brand owners don't have to file notice and takedowns. Unfortunately, that isn't always perfect, and we'll touch on that, but we continue to invest in protection. I have a mix of 2017 and 2018 data here, so don't think that we just stopped in 2017. But we did invest $200 million in 2017. We have 3,000 people worldwide working on this. Our ratio of proactive efforts to reactive efforts is about 100 to 1. 99.9% of the products listed on Amazon never receive a notice of infringement. We've stopped almost 900 million bad and suspect listings from ever going live on any of the Amazon sites. Notices of infringement are down 45% year over year as of July 2018. And customer complaints are down 31% year over year for counterfeits. So while we're very proud of that, we still see that 0.1% that is still a problem, and we're continuing to double down and increase our investments so that we can stop that too. As sophisticated as our tech tools are, and we continue to invest in them, they're unfortunately not perfect. So another way that partnership helps is it helps us tweak these tools and make them more effective for brand owners. Here's kind of a funny thing that happened when we first started using customer reviews as part of the algorithm to detect counterfeits. All of the artificial Christmas trees started disappearing from Amazon sites. There's nothing wrong with these products. They were real fake Christmas trees. But when people were putting fake in their customer reviews, it was triggering our algorithm and those products were coming down. Of course, that happened during the holidays, because why wouldn't it happen then? So again, like I said about partnership, we are constantly working on these tools to make them more effective. We fix this problem. But that type of partnership helps us work on our proactive tools, and then will ultimately cut down on your workload. Brand Registry is something we launched in April of 2018. It's a new tool that we're using to help brand owners enforce their rights on Amazon. It's completely free to all brand owners. It gives rights owners powerful image search technology that I'll give an example of. And it also allows rights owners to provide us with additional information, which then we can feed back into our technological tools to help prevent things from even going live on Amazon. So why enroll? I mean, that's kind of the ultimate question here. So the proprietary text and search technology, which I'll show you, I think is for me as a user of Brand Registry, is one of the more compelling reasons. But you also get increased, as a seller, you get increased detail page controls, which is also appealing. For notices submitted through Brand Registry, 95% of those are removed within 8 hours. And for brands that are in Brand Registry, we notice an 88% decrease in the notices they have to submit. In the interest of time and getting through this so we can go to the reception, I'm not going to go read you all of the enrollment criteria, but we really want to just ensure that your rights are legitimate, and then get information that's going to help us help you. Here's a quick screenshot of the report of violation tool. This is something that you can use to search globally. This can search all of the Amazon websites. And you can also search by image, and you can submit multiple notices of infringement. Some of the feedback that we've received is that people don't want to continuously keep filling out the infringement forms. So this allows you to do a bulk submission, which will streamline your workflow. You also get a way of tracking all of your submissions. So if you want to review a log of reports on the things you've submitted, the status, that can help you run your own metrics on enforcement, or even help you kind of troubleshoot an issue that you're seeing with Amazon, then help us in that partnership to be more effective in taking things down. So I don't know if I mean, I'm going to date myself here, but if you recall the 1980s, there was a commercial for a company called the Hair Club for Men. And at the end of that commercial, the CEO would say, I'm not just the president of the Hair Club for Men, I'm also a client. So here's my similar pitch. Not only am I encouraging folks to sign up and use Brand Registry as a tool to protect their own brands, I and my team use it to enforce Amazon intellectual property on Amazon sites. So one of the problems that we've been seeing and increasingly enforcing against is sellers who add Amazon logos to their detail page images. So I'm not exactly sure why people do this, since these images are appearing on Amazon anyway, but there is, I guess, some perceived lift in having an Amazon logo on your detail page image. This is particularly problematic on a seasonal basis, so we see a lot of this during Prime Day or Black Friday. We can upload an image of the Amazon logo through the report a violation tool, and then that will actually find that logo appearing on detail page images. So if you're searching for something similar, you can imagine what a powerful tool that could be. And then using the kind of the sorting features on the side of the report a violation tool, we can then drill down and separate out logos that might be appearing on some of Amazon's private label products, like our Basics products, or on someone who really shouldn't be using it. We then submit these violations through the report a violation tool, and most of these are down in a matter of hours. So if you do have an issue on Amazon, here's all the different ways that you can reach out to us. Brand Registry is the one that I recommend and use myself. You can also use our public notice form, and the link is in the materials. You can email copyright@ if you want to contact us by email. And then a couple of suggestions to end on. One, clearly articulate the rights that you're trying to assert. I was in private practice for 12 years, and I know that there is a kind of a feeling that if I throw every type of violation into my complaint, maybe it'll be more effective. That's really not the case, and that can sometimes confuse or slow down the process. So don't throw everything at the wall and see what sticks. Focus on partnership. We want to help. I'm here. I'll be at the reception. If you have an issue, give me a business card, maybe write the problem on the back, and we will get back in touch with you. Thank you.
You might have thought that Mike Kelly from Amazon was here to talk about Amazon's policies, but really, he was paid $5,000 by Hair Club for Men. And I felt a need to disclose that because I was paid $10,000 by a competitor for Hair Club for Men to show you what happened when I went to Hair Club for Men. Now, I've tried to bring just a little bit into reality what's going on the internet, because that's what's going on. The purpose of trademark law, according to the books I teach from, and Professor McCarthy's treatise, which has been cited over 6,000 times by courts in the United States, are twofold: to protect brand owners and their investment in the brands, and to protect consumers. Thus, we all know you can argue trademark cases along both of those lines. Consumer confusion is a doctrine that grew up to effectuate this policy goal of protecting consumers. If you think about it a little bit more deeply, and you go back a little further, I suppose, in the history and foundations of trademark law, both of those could be subsumed under even yet a more general goal, which is a trademark cements the bond between the brand owner and the public, the consumer. And much of trademark law for the last 100 years has sought to keep that bond cemented. And you can look at almost every aspect of it, from likelihood of confusion to dilution to fair use and its limitations. So where does that bring me in the online world? Well, I was asked by Barton Beebe and Jeannie Frommer at NYU if I would say a few words about a very provocative book written not by a trademark lawyer, but by a professor of marketing at Stanford, Itamar Simonson, and his co-author, Emmanuel Rosen, who wrote a book and published it 4 years ago called Absolute Value. And I got to thinking about this book because it sits right here at this intersection between the trademark as a legal entity and the trademark as a marketing entity, if you will. And what he says is, and this is just from a review, I quote from him that I got from Amazon, going against conventional marketing wisdom, Absolute Value reveals what really influences customers today and offers a new framework. He calls it the influence mix, a total new way of thinking about consumer decision-making and marketing, and about brands, and about developing more effective business strategies. How people buy things has changed profoundly in the age of the internet. Yet the fundamental thinking about consumer decision-making and marketing has not. I would say the same for trademark law. Most marketers still believe that they can shape consumers' perceptions and control brand identity and drive consumer behaviors. In this book, Professor Simonson, argues that that's not so much the case anymore because of the influencer mix. And what he points to is reviews of products online, consumer reviews, professional reviews. Have you ever gone on YouTube and looked at all the allegedly professional reviews of everything? I cannot tell you how much time my 16-year-old son looks at these and then shows them to me. And every time, my eyes glaze over, I lay in bed, and I said, I think he's being paid. And my son says, no, he's not. He's, Potty Boy or whoever, you know, it's so-and-so. He's famous. He has a Lamborghini. And I'm like, he's being paid. And what resonates with me about this is about trademarks in the online world. You know, the online world really is only, 15 years old? And one of the questions it raises for me is, what is the reliability? I know it's 1999, don't mock me, but I mean, things didn't really get cooking until 2005. What is the reliability of the information mix that we're getting? Who's putting it there? Maybe the brand owners, maybe their competitors. But the reliability of the brand is being impacted by it greatly. Advertising companies know this. They're working with the brand owners to put this information out there. Is it being regulated? No. The Federal Trade Commission wants to regulate it as a form of native advertising or false advertising. Is it being regulated? No. I asked the question of the folks on the panel, particularly the platforms and the lawyers who are here who represent brand owners, what is happening in the world? Are you ever asked by clients to get some reviews taken down because you didn't place them and you think that they're hurting your company and they're false? Have you ever, they won't answer this question, worked with advertisers to put reviews up? And what, if anything, should be our attitude and our viewpoint towards this? So with that, I want to put that question to the platforms online, put them on the spot, and ask them a little bit about policy, or to the lawyers, anybody who wants to speak to it, from the panel, if you have something that you've got to address that question.
So we do take, I think I have a couple of comments. Right, first of all, I do agree that the online world is very different from offline world in the sense of how you shape the consumer. So in fact, on our platform, we do, the reason we offer different business model on different platforms is to offer the rights holder the flexibility of doing their own shaping, right? So for example, I give you an example. So on our platforms, right? If you go to our platform to do a search item in China, so you will see a mix of items from Taobao, which is a C2C platform, as well as a B2C platform with Tmall. So Tmall is actually a brand-driven platform, meaning that the brand can put on their flagship shop and advertise their own product. But generally speaking, we put the Tmall items ahead of the Taobao items. So the reason are twofold, right? First of all, it's the Tmall is actually paid customer, so we want to promote their traffic. But at the same time, for brand owners, this is actually a great tool for advertisement, right? The consumer want to look for information. Now in China, people don't go to brand website to look for information. They probably search online, but then the online information is influenced by a lot of other factors. It's not totally reliable. But they do search on our platforms. And the information they will see at first is brand-owned flagship shop. So if you put information on there, then the consumer can see that information that actually shape their shopping behavior. They may not necessarily purchase from the flagship shop, but when they go to the C2C platform, try to find a seller, maybe offer a better price, maybe offer a better service, maybe they offer purchase from a foreign marketplace and ship back to China. No matter what, but they're armed with the information that's provided by brand. So this actually is an important tool, not necessarily as an IP enforcement tool, but since IP enforcement is related to market, it's at least a very good thing to think about when you have a strategy in China. Obviously, you need to secure your brand, you need to secure a marketing strategy, but that's at least that it should be in your toolbox. Now, for the consumer review part, we do find it's actually, we call it a kind of gray black marketplace because it's not clearly unlawful. Probably is unlawful, but there's not so many cases dealt with this issue. But what we use, as I already said in my presentation, we have transaction data and logistic data, all those things. We actually have an algorithm that's designed to detect those fake reviews because you want to see the transaction actually happens. You want to see the logistic actually happens. Then you think the review maybe is legit. But
You
not
can I just interrupt? You
Yeah.
can tell from your algorithm if the reviewer engaged in the relevant transaction?
Yes, because we have a payment system. So the all our transaction on our platform is done through our end financial arm. So that we can see the transaction, and we have a logistic arm that basically show the tracking information. So we want to see the transaction happen, and we want to see the logistic happen. Then a review may be more reliable, not necessarily, but then there are other patterns that we look for to try to find those bad reviews or fake reviews. In fact, I think we already filed a lawsuit against some company or individual. I forgot, probably an individual, actually bulk putting up those fake reviews. So we do take that very seriously.
Do we have any questions from the audience? Okay, yeah. Go ahead.
Sorry, I know everyone wants to leave. In this age of e-commerce and obvious globalization, what do you guys think the future of global trade rules and laws will look like? Do you anticipate that the laws will proactively change to accommodate, or will businesses have to get more and more creative to navigate the new IP landscape? Thank you.
I think law definitely will change. Like the China already implemented e-commerce law, right? But I don't think certain principles like territorial principle will change. So you have to find a creative way to navigate the system, and we are trying, right? In fact, we have an initiative called EWTP, which sort of try to reduce the tariff for things like that to facilitate small business to do cross-border transaction. But I think it's actually a combination of evolvement of law and the creative thinking of the platforms. You know, we provide the tools. We try to reduce the time of the logistic to do cross-border transactions. But at some point you need to comply with the law, right? At least so far for us, you know, we have operate our online notice takedown system without any clear guidance in China for a long time, and our principle is just to address the issues. So that's our principle. We need to comply with law, but our goal is to address the issue. So I see that principle will apply to any of those cross-border transactions.
That it? We'll let it be done with that. All right, I think what we're going to do is say thank you to the panel, please. And before you leave, we have a lovely reception with variety types of alcohol and food across the hall. I do want to thank our sponsors and speakers. I want to thank NYU. First of all, if you would give a hearty thank you to NYU for being so gracious to host us, and to Jeannie Frommer and Barton Beebe and Michael Weinberg, the executive director. They put in a lot of work to make this happen. I want to thank Golden Gate University and the McCarthy Institute and everybody who worked for them, including AMS, Associated Management Solutions, who has helped us with offsite logistics. If you would say thank you to those people. I also want to thank the speakers. All of the speakers were fantastic, and we were fortunate to have them. The sponsors, Seed IP, Russ Pangborn, Shepard Mullen, the EU IPO, Perkins Coie, Fish Analysis Group, Hogan Lovell, Keystone, Banner and Witkoff, Unitalon, INTA, Bereskin and Parr, Debevoise and Plimpton. We thank all of them. And I want to give you also 2 announcements. We're going to have another conference, McCarthy Institute, at the USPTO in Alexandria, Virginia, on anti-counterfeiting on June 6th of this year, and then another one on September 26th and September 27th at the EU IPO office and theater in Alicante, Spain. And it's going to focus on global trademark rights and issues and the TM5. And so we look forward to seeing at least some of you, I hope, at some of these other events. So thank you very much and enjoy yourself.